Good morning and welcome back to the e-Discovery Zone. This is Tom O'Connor without Browning Marian of DLA Piper, who has gone off globe hopping someplace on a new jaunt to Hong Kong or Australia or Mongolia or someplace that DLA has just opened an office. So I'm winging it alone in our last session of the morning. I'm joined by attorney David Chaumette of De La Rosa and Chaumette in Houston, Texas.
Yes.
And Julie Brown, who is the Lit Support Manager at Vorys in Columbus, Ohio, although you have more offices than that.
Yes.
Yeah. So thank you very much for joining us. I understand you're fresh off of a panel discussion on project management,
yes,
which is a subject near and dear to my heart because most of my clients don't know what it is. We were talking just before we started about getting an org chart or a data map as the first step. I'd just like to hear your experience on that.
Well, you know, when I go in for initial meeting, that's usually one of the first things I ask for. It's like, can you give me an organizational chart or the electronic version of it, which is a data map, so that we know where everything is. And usually I'm greeted with stunned silence because even in the most complicated, sophisticated, Byzantine, bureaucratic organizations, they don't have one of those. Well, the exercise is not so much to see what they have, but also it's to figure out where the custodians are, who the custodians are, what type of data we're dealing with. And I fully recognize when I ask for this sort of thing, that it's not going to be perfect when we get it. And as soon as it's delivered to you, it changes.
Right.
And so, you know, don't let yourself get hung up on the fact that they can't give it to you right away, and don't get hung up on the fact that the minute that they give it to you, it's wrong. It's at least a starting point, and you're much better off with one than you would be without it.
Right. I'm also curious, in dealing with your clients, do they have someone like Julie? Are you seeing more or any corporate clients with lit support staff? We know they may have general counsel, but how about lit support people?
Yeah, there's more.
We're actually seeing the larger companies that are frequently involved in litigation have really put together some pretty sophisticated teams of litigation readiness plans, and they have folks that are in lit support, they have attorneys, they have their records people on board, and actually sometimes, I mean, I walk in and it's like, you tell me what you want us to do, because they've evolved. Now, there's still a ton of companies that don't have anybody, you know, and quite frankly, they're not in litigation enough to justify going out and hiring a huge department to manage it.
Those are the problems I see with a medium-sized company. I'm working with an oil drilling company right now in New Orleans. They're not serial litigants. They're involved in a large case. This is all alien to them.
Right.
So yeah, how do you deal with a client like that?
Well, you know, it's funny. We just came off this panel talking about project management. It is so important to get in early and have those discussions early with them because, you know, looking at it macroscopically as a litigator, I don't want to surprise the client with how big the bills are going to be at the end when I had the opportunity to discuss not only the size of the bills, but frankly, some cost-saving measures that we could have taken at the beginning.
Okay.
And so you have those discussions from the very beginning. One of the concerns that I have is there are a number of clients that have very sophisticated people in the house. And with that comes often pre-selection of vendors and processes that are already established, but they're not always, they haven't always been tested.
Right.
And we're starting to see more and more judges come and say, okay, how do I know that you've actually not only done what you said you were going to do, but that it would achieve enough of the result, that we know that you've gotten a responsive set of documents? What testing have you done? So you really do have to look inside the black box or go behind the curtain and ask those kinds of questions. And in the more sophisticated clients, they're ready for that. They have a documented plan, and this is how they're going to do things. For the folks who just assigned the slowest person the lit support role, it can be a little bit more of a challenge sometimes. And by slowest, I mean the person didn't move fast enough.
Right. Now, it's a little bit off of the topic that you were just speaking on, but you brought up the issue of the cost and not shocking the client. You probably saw last year Craig Ball had his Edna challenge, assigning a $1,000 budget to an e-discovery case and trying to find anything that would help him do that. We're updating that, and I've actually posted it first time just before the tech show. We're calling it the Ernie Challenge after a friend of mine who's a solo attorney, Ernie Svensson in New Orleans. He's a speaker here at the show as well. And we're asking people, what do you do if you have a case with a couple of 100 gigabytes and you might have a $50 or $60 or $70,000 budget, that still isn't going to touch going to, I won't name any specific products because I don't want to single somebody out unfairly, but paying $400 or $500 or $600 a gigabyte just to process, not even to get to the review stage. What do we do with those tweener cases?
Well, I mean, you know, this came up in our panel. The most important thing you can do is pick up the phone and talk to the other side.
It's just what Judge Waxy said.
Right.
Judge Waxy said.
To me, that's where our attorneys can really offer a lot of value, and strategically, planning how they're going to handle this and negotiating that with opposing counsel. And I think, that's where attorneys usually, really, especially litigators, do well, is in the negotiation thing. And you're not negotiating settlement, but you're negotiating how you're going to proceed on the case, and it's really critical.
Imply a certain sophistication or technical knowledge on the other side. I mean, Judge Waxy's statement was, we need to change Rule 1 to read not just the courts shall encourage or the court shall meet this standard, but the parties are obligated to meet this standard as well. What do you do with somebody who's obstinate and is really more interested in winning than cooperating?
I presume no knowledge on the other side. And
you're rarely disappointed.
Exactly. I think you're absolutely right to bring up the judges, because when the rules changed, corporations were up in arms about all the new work that they'd have to do. But really, the group that got tasked with a lot of new work were the judges. The judges have to get more involved in their cases earlier. So if we have those sorts of situations, I do what I can to find out how we get in front of the judge in an informal way. Because a 10-minute conversation with the judge over the phone can resolve a lot of these disputes very, very quickly. And we may lose the first one, we may have to do more than we need to, but sooner or later, we're not being unreasonable.
But you said something interesting. I brought this point up in a session I did yesterday. A 10-minute phone conversation. You're not talking about a formal pleading or a motion. Let's just bring it to the judge and say we need to work this out.
And that's, as Julie was saying, that's frankly where lawyers can add a ton of value. By knowing the courthouse well enough to know, call the case manager, say, listen, we just need 5 minutes of the judge's time on the phone. We'll set up the teleconference. We just need the judge to come in and tell us what she thinks about this scenario and how we should proceed. We don't need to file a bunch of motions. We don't need a bunch of affidavits. That wastes everybody's time.
Right.
And at the end of the day, yes, I have lawyers in cases where they're about making me, one of my clients calls it wallet whipping. It's a very Texan phrase. They're trying to wallet whip me. but at the end of the day, the judges know the wallet whippers too, and they see it coming.
Right.
And so if it encourages you as a litigator to step back from zealous advocacy in a direct way to a more indirect sort of I'm trying to be reasonable. I'm going to give you what I think you need. If you need more, tell me why and share the cost with me. And immediately that diffuses some of the balloons and some of the anger and hopefully gets you to the right result. Can't guarantee it,
right,
but it helps.
But you made an interesting, almost an aside there, strategically, that puts you in a good light with the judge.
Oh, yeah.
That you've been the reasonable party, that you've made the effort.
And I hate to be too much of the Texan, I said this during our session. I talk to my clients often about white hats and black hats. And I'm going to grab the white hat and jam it on my head so hard as early as possible.
Right.
And that's a way of being an indirect advocate for your client, so that when the fights really matter, you've got the credibility with the judge. The judge knows that you're not trying to just jack the other side up in terms of costs, even if you are. But if you just be more reasonable, and honestly, what I have found, even the other side that knows nothing about e-discovery gets it soon enough that they figure it out. And if they don't, woe to them.